Most people spend their entire lives building wealth and then accidentally hand it to the wrong people. And the scary part? It happens all the time. Right now, someone's life savings is sitting in a courtroom frozen while their family waits outside, broke. And the only reason it's there is because of one mistake most people never think about. So today, we're breaking down exactly what happens to your money when you die and the moves that separate people who protect their wealth from the ones who lose it. Here's something nobody tells you when you open a bank account, buy a house, or start investing. Every single thing you own has a destination after you die. The question is, did you choose that destination? Or did the government choose it for you? Because if you don't have a plan, the law has one ready for you. And it's probably not what you'd want. This isn't just for rich people either. Whether you have $10,000 or $10 million, the same rules apply. And most people are completely unprepared. Part 1. What actually happens first? The moment you die, something called your estate is created. Your estate is simply everything you own: your bank accounts, your home, your car, your investments, even your debts. And here's the part most people don't realize: your family doesn't automatically get access to any of it. Not immediately. First, there's a legal process that has to happen. It's called probate. And probate is where things start going wrong for most families. Probate is a court-supervised process that verifies your will if you have one and decides how your assets get distributed. Sounds simple enough, right? But here's the problem. Probate is slow, expensive, and completely public. In some states, it can take 1 to 3 years. And the fees, legal fees, court fees, executor fees can eat up anywhere from 3 to 8% of your total estate. That's not a small number. On a $500,000 estate, that's $40,000 gone before your family sees a single cent. And here's what makes it worse. While probate is dragging on, your family may not be able to touch anything. Not the house, not the savings account, not the car. They're locked out. Part 2. The will myth. Now, at this point, you might be thinking, but I have a will. I'm covered. Not exactly. This is where things go wrong and where most people make the biggest mistake. A will does not avoid probate. Let that sink in. A will still goes through probate court. It just tells the court what you wanted. The court still controls the process, the timeline, and the fees. A will is better than nothing, absolutely. But it's not the protection most people think it is. And there's something else. What if your will is outdated? What if you wrote it 10 years ago, before you got remarried, before you had kids, before your circumstances completely changed? Courts have seen cases where an ex-spouse inherited everything legally because the will was never updated. Here's the part most people don't realize. A document you wrote years ago could completely override your current wishes. That's not a loophole. That's the law. Part 3. What happens without a will? Now, imagine dying without a will at all. This is called dying intestate. And it's more common than you'd think. Studies show that over 60% of Americans don't have a will. When you die intestate, the state decides who gets what. There's a legal formula called intestate succession, and it follows a rigid hierarchy. Spouse first, then children, then parents, then siblings. Sounds reasonable maybe. But what if you were estranged from your family? What if you wanted to leave something to a close friend, a charity, a partner you were never legally married to? Too bad. The state doesn't care about your relationships. It only follows the formula. And here's the part that stings: that partner you lived with for 15 years? In most states, they get nothing. Not a single dollar. Because legally, they're a stranger. Part 4. The tools that actually work. So what do people who actually protect their wealth do differently? 3 things. First, they set up a revocable living trust. A trust is a legal structure that holds your assets during your lifetime and transfers them directly to your chosen beneficiaries after you die, without going through probate at all. This is the single most powerful tool in estate planning. No court, no waiting, no public record. Your family gets access quickly, privately, and with far less cost. Now, this might sound small, but it changes everything, especially for families who need access to funds quickly after a loss. Second, they update their beneficiary designations. Here's something most people completely overlook. Your retirement accounts, your life insurance policies, your bank accounts, these pass outside of your will entirely. They go directly to whoever is listed as the beneficiary. Doesn't matter what your will says. Doesn't matter what you told your family. If the wrong name is on that form, that's where the money goes. Period. People have accidentally left retirement accounts to deceased parents because they never updated the form after getting married. Check your beneficiary designations. Right now, not next week. Third, they use joint ownership and transfer on death designations strategically. For certain assets, especially real estate, adding a co-owner or setting up a transfer on death deed can pass property directly to someone without probate. It's simple, it's legal, and it saves enormous amounts of time and money. Part 5. The taxes nobody talks about. Now let's talk about something most people try to avoid thinking about. Taxes, specifically the estate tax. At the federal level, estates under $12 million are currently exempt from estate taxes. That sounds like a lot, and for most people, it is. But state-level estate taxes are a different story. Some states have exemptions as low as $1 million. And as property values rise, as retirement accounts grow, more and more middle-class families are getting caught by state estate taxes they never expected. And here's the part most people don't realize: those exemption thresholds are set to change. The federal exemption is scheduled to drop significantly after 2025. If you're not planning now, you could be handing a significant portion of your estate to the government instead of your family. Part 6. The conversation you haven't had. Here's the uncomfortable truth. Most estate planning failures aren't legal failures. They're communication failures. People die without telling their family where accounts are held, without sharing passwords, without explaining who gets what and why, and this creates conflict, painful, sometimes permanent conflict among people who are already grieving. Some of the most devastating family disputes aren't about big fortunes. They're about small things: a grandmother's ring, a car, a savings account that two siblings both thought was promised to them. Having the conversation, the real, direct, documented conversation about your wishes, is just as important as having the legal documents. Sometimes more. Here's what it all comes down to. Your money has a destination after you die. You either choose it or someone else will. The legal system isn't designed to protect your wishes. It's designed to follow rules. And those rules may have nothing to do with what you actually wanted. The good news is, this is completely fixable. A will, a trust, updated beneficiary designations, and one honest conversation with your family. That's it. That's the difference between your wealth reaching the people you love and disappearing into courts, fees, and family conflict. You built it. Protect it. Don't let a missing document be the reason your family suffers.